A sudden move to federal court is never an act of confidence. It is an act of urgency. When a powerful individual abandons public messaging and rushes behind courtroom doors, it signals that something fundamental has shifted. This is not about routine legal procedure. It is about damage control, containment, and fear of consequences that can no longer be delayed. The testimony that triggered this moment did not rely on rumor, speculation, or political noise. It was structured, sworn, and delivered under the weight of federal law. Such testimony is designed to lock facts into the record, facts that cannot be erased by press conferences or online statements. Once spoken under oath, they become permanent, actionable, and legally dangerous. The speed of the response tells its own story. There was no period of silence, no measured review, no calm rebuttal. Instead, there was a scramble, an immediate attempt to intervene before momentum could build. In legal history, this kind of reaction is often seen when a line has been crossed, when evidence threatens to connect actions to accountability in a way that cannot be spun away. Federal court is not a stage for theatrics. It is a place governed by rules, documents, timelines, and consequences. Judges do not respond to outrage or loyalty. They respond to law. Entering that arena under pressure means facing professionals whose only concern is whether statutes were violated and whether the evidence supports that conclusion. What makes this moment especially significant is that the testimony did not emerge in isolation. It followed months, if not years, of investigative groundwork. Witnesses are not placed forward lightly at this level. When testimony reaches this stage, it usually means corroboration exists, records have been examined, and narratives have been tested against facts. This is why the rush matters. It suggests that the legal strategy has shifted from offense to defense, from denial to containment. It reflects a realization that the system being confronted is not political opposition, but institutional law enforcement, slow, methodical, and largely indifferent to public pressure. History shows that moments like this often mark the beginning of a longer unraveling, not because of a single statement, but because testimony opens doors. It leads to follow-up questions, document requests, and additional witnesses. Each step narrows the space for evasion and increases the clarity of responsibility. Regardless of how this unfolds, one principle stands firm. No individual, regardless of status or influence, is immune from legal scrutiny. Courts exist precisely for moments like this, when power collides with evidence and narratives are tested against sworn truth. This is not merely a legal episode. It is a stress test of institutions, a reminder that accountability does not operate on political schedules, and a signal that when testimony reaches this level, the consequences are no longer hypothetical. They are real, imminent, and governed by law alone. Urgent legal action is rarely a sign of strength. More often, it is an instinctive response to sudden exposure. When a powerful figure moves rapidly toward federal court, bypassing the usual buffer of public messaging and political framing, it suggests that the situation has crossed from manageable controversy into genuine legal danger. Confidence allows time. Vulnerability demands speed. The haste itself becomes evidence, not in a courtroom sense, but in how it reveals internal calculation and concern. In high-stakes legal environments, timing communicates intent. A calm actor assesses options, consults advisors, and prepares a deliberate strategy. A rushed actor is reacting to events rather than shaping them. The immediacy of the court filing implies that the testimony created an unforeseen risk, one that threatened to gain momentum if not addressed instantly. This kind of response often reflects fear of escalation, fear that additional witnesses may come forward, that documents could be requested, or that investigators may interpret silence as weakness. Such urgency also indicates that informal defenses have failed. When public denial, political loyalty, or media counter-narratives are no longer sufficient, the only remaining shield is procedural intervention. Federal court becomes the last line of defense, not because it is favorable, but because it is unavoidable. The rush suggests that legal exposure is no longer theoretical. It is active, forming, and potentially irreversible. There is also a psychological dimension to urgency. Power is accustomed to control over messaging, timing, and perception. Sudden testimony under oath removes that control. It introduces an independent voice bound by law, not loyalty. The rapid move to court reflects an attempt to regain control, to interrupt the sequence before it solidifies into a formal legal pathway. In this sense, urgency is not strategic brilliance. It is an effort to stop bleeding. Historically, rushed legal maneuvers often follow moments when insiders realize that the facts on record may soon outgrow their ability to contain them. Once testimony is logged, it invites verification. Verification invites expansion. Expansion invites accountability. The speed of the response implies awareness of this chain reaction and a desire to break it early, even if doing so appears desperate. Urgency also signals asymmetry. The responding party knows more than the public does. Observers may see only a single testimony, but the reaction implies knowledge of additional vulnerabilities, documents, communications, or actions that could align dangerously with sworn statements. Courts are not moved by speculation, but those rushing to them often are. They act not on what has been proven yet, but on what could soon be proven. Ultimately, the urgency exposes a shift in power dynamics. The moment legal actors, rather than political ones, begin to dictate the pace, urgency replaces confidence. The rush to federal court is not about asserting dominance. It is about minimizing damage in an environment where control is slipping and where the next move may no longer belong to the person rushing through the courthouse doors. Sworn testimony fundamentally alters the terrain of any legal confrontation because it converts narrative into record. Statements made under oath are not flexible talking points. They are binding declarations subject to criminal penalties if proven false. This shift is critical because it removes ambiguity and replaces it with accountability. Once testimony is delivered in a formal legal setting, it ceases to be an opinion or allegation and becomes a fixed element of the judicial process. The power of sworn testimony lies in its permanence. Media cycles fade, public attention shifts, and political debates evolve, but testimony remains preserved in transcripts and filings. Investigators, judges, and prosecutors rely on this record as a stable foundation upon which further action is built. Each sworn word can be revisited, cross-referenced, and tested against documents, timelines, and other witnesses. This durability makes testimony uniquely dangerous to anyone whose defenses depend on shifting explanations. Another crucial aspect is legal exposure. Testimony creates legal obligations not only for the person speaking, but also for those implicated by the statements. Once facts are asserted under oath, they impose a duty on the justice system to examine their validity. If corroborated, they can justify subpoenas, search warrants, or indictments. If contradicted, they may trigger perjury investigations. Either path increases scrutiny and reduces room for maneuver. Sworn testimony also establishes intent, which is often the most difficult element to prove in complex cases. Documents may show actions, and timelines may show sequence, but testimony can clarify motive, awareness, and decision-making. When a witness explains what was known, when it was known, and how decisions were made, it helps prosecutors connect actions to legal standards. This is why testimony is frequently the turning point in high-profile cases. It provides the human context that documents alone cannot. Equally important is the way testimony constrains future statements. Once something is said under oath, it limits the ability to later claim ignorance, confusion, or misunderstanding. Inconsistencies between sworn testimony and later public or legal statements can be devastating. They create credibility gaps that opposing counsel can exploit and judges can weigh heavily. The record becomes a measuring stick against which all future claims are judged. Testimony also has a cascading effect. One sworn statement rarely stands alone. It invites corroboration or contradiction, prompting investigators to seek additional witnesses who can confirm or challenge the account. This expansion is not optional. It is a procedural necessity. The legal system is designed to follow leads generated by sworn statements, especially when they touch on matters of public interest or potential criminal conduct. Perhaps most importantly, sworn testimony shifts control away from the subject of investigation. Once testimony is entered, the process moves according to legal rules, not personal preference or political strategy. Timelines are set by courts, not by press teams. Responses must be made through filings, not rallies or interviews. This loss of control is why testimony is often met with such aggressive legal responses. It signals that the matter has moved into a domain where influence is limited and consequences are governed by law. Speed is rarely neutral in legal strategy. When a response comes almost instantly, it suggests that the situation has moved beyond calculated messaging into reactive defense. Measured confidence allows time to evaluate options, test arguments, and choose the most advantageous path. Rapid action, by contrast, indicates that waiting is perceived as dangerous. That delay could worsen exposure or allow events to unfold beyond control. A fast response often reflects a shift from offense to defense. In earlier stages of controversy, public figures tend to attack accusers, question motives, or dismiss developments as insignificant. These tactics rely on shaping perception and buying time. When those approaches are abandoned in favor of immediate legal intervention, it signals that perception management is no longer sufficient. The battleground has changed, and the tools that once worked are no longer reliable. Defensive speed also reveals concern about momentum. Legal processes are cumulative. Once they start moving, they tend to accelerate. Testimony leads to filings, filings lead to hearings, and hearings lead to rulings. Acting quickly can be an attempt to interrupt that sequence, to pause or redirect the process before it gathers force. The urgency implies awareness that each additional step increases risk and narrows available options. There is also an implicit acknowledgement of asymmetry. The responding party understands that investigators and courts operate methodically and persistently. They do not tire, lose interest, or get distracted by headlines. Speed becomes a way to compensate for that imbalance, to act before the institutional machinery fully engages. In this sense, haste is defensive not just legally, but structurally. Rapid legal action can also indicate internal pressure. Advisors, attorneys, and confidants may recognize vulnerabilities that are not yet public. Documents, communications, or prior statements may align uncomfortably with sworn testimony. The speed of the response suggests a desire to get ahead of these issues, to frame them within a legal argument before they are framed by someone else. Acting first can sometimes shape the initial contours of a case, even if it cannot change the underlying facts. Another dimension of speed is constraint. Once testimony exists, silence can be interpreted as acquiescence or inability to respond. Delay risks allowing opposing narratives to harden into assumptions. Quick action is a way to signal resistance, to show that the testimony will be challenged rather than absorbed. Yet the very need to signal this resistance underscores defensiveness. It reflects anxiety about how the record might be interpreted if left uncontested. Finally, speed reveals diminished flexibility. Defensive strategies often aim to limit damage rather than achieve victory. They focus on narrowing issues, excluding evidence, or delaying outcomes. These goals require prompt action because procedural windows close quickly. The rush indicates that those windows are perceived as small and closing fast. Taken together, the lack of delay is not merely a tactical choice, it is diagnostic. It reveals a recognition that the situation has escalated, that passive strategies are no longer viable, and that the primary objective has shifted from control to containment. Federal courts operate in a fundamentally different universe from political arenas or media platforms, and that difference becomes decisive when disputes cross into the judicial system. In this environment, influence, popularity, and rhetoric lose their power. What matters instead are statutes, precedent, admissible evidence, and procedural compliance. This shift strips away many of the advantages that powerful figures rely on outside the courtroom. Unlike public debates, federal courts are indifferent to emotional appeal. Judges are trained to disregard outrage, loyalty, and spectacle, focusing instead on whether the law has been followed and whether evidence meets established standards. Arguments must be grounded in legal authority, not persuasion of an audience. This creates a setting where past success in commanding attention or shaping narratives provides little advantage. Evidence is the currency of federal court. Documents, sworn testimony, financial records, digital communications, and timelines are examined in detail. Assertions unsupported by proof are quickly dismissed. This emphasis creates risk for anyone whose defense depends on ambiguity or denial. Federal procedures are designed to narrow disputes to verifiable facts, reducing the space for reinterpretation or revision. Another defining feature is institutional memory. Courts maintain records meticulously, and filings become part of a permanent archive. Inconsistencies are preserved and can be revisited months or years later. This permanence means that short-term messaging strategies are ineffective. A statement made in haste, a claim unsupported by evidence, or a contradiction between filings can resurface and compound legal exposure. Federal courts also function independently of electoral cycles and public opinion. Judges are insulated from political retaliation and are bound by lifetime appointments or long tenures. This independence allows them to make unpopular decisions without fear of immediate consequence. For individuals accustomed to leveraging public pressure, this insulation represents a loss of leverage and control. Procedural rigor further limits maneuvering. Deadlines are fixed, discovery obligations are enforceable, and sanctions exist for non-compliance. Attempts to delay, obstruct, or overwhelm the process are often met with judicial resistance. The system is structured to progress steadily, even in the face of aggressive legal tactics. This predictability favors institutions over individuals. The adversarial balance is also significant. Federal prosecutors and opposing counsel are typically experienced specialists with deep resources. They operate within a framework designed to uncover truth through structured confrontation, cross-examination, evidentiary challenges, and judicial oversight ensure that claims are tested rather than accepted at face value. This environment is hostile to improvisation and exaggeration. Most importantly, federal courts prioritize accountability over outcome. The goal is not to satisfy public expectations or preserve reputations, but to apply the law consistently. When evidence supports a finding, the system moves toward resolution regardless of status or consequence. This reality explains why entry into federal court marks a turning point. It signals that the matter is no longer governed by influence or persuasion, but by rules that apply equally and relentlessly. A single sworn statement rarely represents the end of a legal matter. More often, it marks the beginning of an expanding process. Testimony functions like a trigger within the justice system, activating mechanisms designed to pursue clarity and consistency. Once a witness places facts on the record under oath, those facts demand verification. The system is not built to accept testimony at face value and move on. It is built to ask what else supports it, what contradicts it, and what remains hidden. This is where the chain reaction begins. Investigators and attorneys analyze the testimony line by line, identifying claims that can be tested against documents, communications, or timelines. Each verifiable statement becomes a lead. If a witness references meetings, emails, or decisions, those references justify requests for records. Subpoenas follow naturally, not as escalation, but as procedure. The testimony creates legal justification for expanding the scope of inquiry. As new evidence is gathered, additional witnesses often become relevant. People who were previously peripheral may now be central because their knowledge can confirm or undermine sworn statements. This widens the circle of scrutiny and increases the number of accounts that must align. Each new witness adds complexity and risk, especially when stories diverge. Inconsistencies do not merely create confusion, they create investigative opportunities. The chain reaction also increases pressure on all involved parties. Witnesses may reconsider their own exposure and choose cooperation over silence. Legal counsel may reassess strategies as the evidentiary landscape changes. What begins as one testimony can alter incentives across an entire network of individuals, shifting the balance between resistance and disclosure. Importantly, this process is largely irreversible. Once investigative momentum builds, it does not dissipate easily. Even if the initial testimony is challenged, the act of challenging it introduces more filings, hearings, and judicial attention. Attempts to suppress or limit the impact of testimony can paradoxically generate additional scrutiny, drawing focus to precisely what one hopes to contain. There is also a temporal effect. Each step in the chain takes time, but collectively, they extend the life of the investigation. Months or years can pass as documents are reviewed, witnesses are interviewed, and legal arguments are resolved. This prolonged exposure increases risk as circumstances change and new information surfaces. What was once manageable can become overwhelming simply through duration. The chain reaction underscores a central truth of legal systems. They are designed to follow facts wherever they lead. Testimony is not an endpoint, but a starting signal. It tells the system that there is something worth examining more closely. Once that signal is sent, the machinery engages methodically, expanding outward until questions are answered or accountability is established. This is why sworn testimony is feared by those with vulnerabilities. It transforms isolated statements into an ongoing process that is difficult to control and even harder to stop. The principle that accountability transcends power and status is foundational to the rule of law, yet it is most clearly tested when influential figures come under scrutiny. Legal systems are designed with the premise that authority, wealth, or public prominence do not exempt anyone from responsibility. When credible evidence emerges, the machinery of justice is obligated to respond in the same manner it would for any other individual, regardless of position or reputation. This principle exists precisely because power distorts ordinary safeguards. Influential individuals often have access to resources that can delay, complicate, or obscure accountability. Elite legal teams, political allies, and public platforms capable of shaping perception. The law counters this imbalance by insisting that facts, not influence, determine outcomes. Courts operate on the assumption that equality before the law is not symbolic but operational. Accountability becomes especially significant when actions intersect with public trust. Individuals who hold or have held positions of authority are not merely private actors. Their decisions can affect institutions, norms, and civic stability. For this reason, scrutiny is not persecution, but necessity. The higher the power, the greater the obligation to adhere to legal boundaries because the consequences of misconduct scale with influence. The enforcement of accountability also serves a systemic function. When legal standards are applied consistently, it reinforces confidence in institutions. Selective enforcement erodes legitimacy, signaling that rules are negotiable for the powerful and rigid for everyone else. By contrast, visible accountability sends a clear message that the system is resilient enough to confront those who once seemed untouchable. There is also a deterrent dimension. Legal consequences imposed without regard to status discourage future misconduct by demonstrating that power does not confer immunity. This deterrence is not abstract, it shapes behavior within political, corporate, and institutional environments. When accountability is real, it recalibrates risk calculations and constrains excess. Importantly, accountability does not presume guilt. It demands process. Investigations, hearings, and trials exist to test allegations, not to confirm them automatically. Subjecting powerful individuals to this process is not an act of hostility. It is an affirmation that the process itself matters. Transparency and due process protect both the accused and the integrity of the system. Finally, accountability is cumulative. Each instance where the law is applied impartially strengthens the precedent for future cases. It narrows the gap between principle and practice, making it harder over time for power to claim exception. This gradual reinforcement is how legal systems evolve from aspiration to reality. In moments of high-profile scrutiny, the outcome matters less than the fact that the process proceeds without deference. That progression affirms a core democratic ideal. Authority is granted conditionally, governed by law, and subject to review. When accountability reaches even the most powerful, it confirms that the legal system, though imperfect, remains oriented toward equality rather than privilege.